I'm going to try to speak a little slower this time because I think I realized that I was speaking too fast and you might have to repeat or put on pause and repeat it again. And you probably had this experience where people leave their phone number on your voicemail, on your answering machine, and they say their number so fast that you have to push the button to repeat it or rewind it a couple of times before you finally get the whole number. So I'm going to try not to do that to you because that's rotten, I think, anyhow. Here we go, another part in workers' comp where some state in the United States makes it workers' compensation the exclusive remedy rule. And what do I really mean by that is that if you are injured in the course of employment, you cannot sue the employer for negligence. You cannot pursue any other claim, like with America with Disability, like we saw that before. So this is where it's very, very interesting about that. What about when an employee is killed or severely injured, however? Is the limit benefit of worker compensation inadequate and an unfair trade-off? And we do have things like that. And like I shared with you at the beginning, we have 1.1 million people that are that in 100,000 asbestos too. We have people that die annually. We have people that died while they are working. Explosion, even entertainment world, they're doing a movie and that happens. And if the workers' comp is the only remedy, is that unfair? Because like I said before, you will never be compensated like if you would take the employer to court for under negligence, because next thing you know, you only got what, dead body? Well, what's the value of a dead body? Maybe a couple of $1,000s. So I know like for the funeral, they give you a couple of $1,000s. So it's really something that ethically, it doesn't sound like it's fair that workers' comp should be the only remedy. And before we go to this case, which is the latest case, I want to go over a little bit toward a case, a Silkwood case, which you probably saw a movie. And it was very, very interesting because in that situation, she was working in the laboratory. And the reason why I want to share this case, because the company was complying with the law. They had a policy again, and the company set up a policy to protect their employees and also to comply with the law, that anybody going in or out of their of the lab cannot have more than 0.5 grams of. They could have it without being detection when leaving the plant. So an employee that was exposed to some kind of plutonium could carry in their body or in their clothes 0.5 grams of plutonium without being detected by the machines or by the metal detector. They could not do it. So here is Silkwood, a young lady, where she would go 3 times a day, like in the morning, and then go maybe out for coffee or lunch, going to her apartment, or in the evening coming because she was living close to the plant. And what in this case was very interesting is they found out so much plutonium in her apartment that they had to burn the apartment. They had to burn the furniture. They had to burn everything that was in it because of the contamination of the plutonium. So here is a situation where she died. And exclusive remedy, what we're going to do here, and I want you to know that this was a very interesting case because the company would be arguing, how can we be liable when we comply with the law? And the interesting thing is the court said that even if you comply with the law, there still could be inference, or they still can be found negligent, because you know best as a company what's going on with the employee. So just because OSHA or any other agency has some kind of a standard, that is the minimum standard. That standard, it tells the employer the safety that has to be in their employment, but does not mean that the fact that they comply with the minimum, that is safe for their employees. And it's really up to the employer to then do better. Very, very interesting, the Silkwood case. And they also got punitive damages. and they were sued for negligence. And one of the things was that in that state, workers' comp was the exclusive remedy, and it went all the way to the Supreme Court of the United States, and it was settled out of court. This case, which is very interesting, and then I'm talking about now torts, and it's in your textbook, and a man was killed at work, and his widow argued that she should be able to sue in tort for wrongful death instead of being confined to work and compensation. Well, ethically, it's not nice that you're suing your own employer. He died. Maybe he had a heart attack, whatever it is. So here is the thing that I find very interesting. How did the court decide it? And I would like you to read the case. What is the worker compensation? What is the worker compensation exclusivity rule? Who benefits from it? Well, you know the employer will benefit from it. There is no questions about it. The workers' comp insurance is to protect the employer, and at the same time have a remedy for the employee. But this statute is being enacted so many years ago that nobody ever changed the price or anything. In the meantime, the employer has to pay the insurance premium. And you know the benefits, health benefits, or anything to do with the insurance costs today so much money, so that they're trying to put a cap, because otherwise it will cost the employer even more the premium to have workers' comp insurance. Why then allow a tort suit when an employer did not intend harm? Another very interesting question ethically, you know, if we're going to say workers' comp is not an exclusive remedy, but then you can sue the employer for tort, but is that right when the employer had no intention to cause harm? Because remember, what is the employer trying to do? To make society better without harming it. So here you're saying negligent. Negligent is no fault. Nobody knows who did it. The only thing you have to make sure is that the employer had a duty. Yes, the employer has a duty to keep the place safe. Did he breach the duty? Of course he did, because somebody got hurt in the course of employment. Did the plaintiff suffer injury? Well, in this case specifically, he died, so I would say definitely. And then was his death linked some way, somehow, to his employment? Yes. So you're thinking like, wait a minute, the employee didn't even know you existed, and next thing you know, he's getting sued on the tort. Assignment. I'd like you to do this assignment, and this is something that I would like to review and find the worker compensation statute in your home state. Under what circumstances can a person file a claim? And you're going to find it very interesting in your home state, or if you don't want to look into New Jersey. And then post your answer on the bulletin discussion board. I would really like to hear what you think about it. Thank you.